most important things that people should leave today's presentation with?
I think the primary takeaway from this presentation and other commentators who have talked about it is that companies should look and see whether they have existing no poaching agreements between companies, between its company and another company. If they do, they should look at the nature of that relationship, whether the agreement spells out any disclaimer as to whether there's a joint venture, collaboration, agency, or anything else that would connect those two companies together to give it some defense with respect to a per se violation. If they're disclaiming those issues and saying they're completely independent companies, then you have to evaluate whether those agreements should be ceased immediately and what the liability is from it. On the wage fixing side of it, if companies are suppressing wages because of agreements, oral or otherwise in writing, then those types of agreements need to be addressed immediately. So my view is, from the HR personnel to the general counsel, pay attention to these types of agreements. There's warnings out in the marketplace. The Department of Justice and Federal Trade Commission are going to stare at those things. You're on notice, so take that pretty seriously. We haven't seen a criminal prosecution yet, but one is bound to be coming if you believe the Department of Justice's warnings and admonitions. Take it seriously and have somebody who has antitrust background stare at those agreements and help you navigate those laws.
Yoon, well, I'll do the same for you. What are the most important things that people should leave today's presentation with?
I think one of the things that I want to highlight is that while no poach and wage fixing agreements have been the subject of the agency's focus recently, the agencies and the private bar scrutiny actually appears to be sort of expanding beyond these specific agreements to other types of employment arrangements. So, and their potential competitive effects. So things like non-competes or even the use of fixed term contracts. And so the firms should be, I think those at the firms should be really taking a careful look at sort of the employment contracts and agreements and arrangements that they have in place to understand obviously the legal implications of these types of arrangements, but also whether they can be justified in a meaningful way in terms of their business and the benefits that it might generate for their business and for the workers themselves. The second point I think is, of course, this is something that would come from an economist, but I think evaluation of potential impact of alleged no poach and wage fixing agreements, I think they actually require careful economic analysis. While on the surface, you might actually expect these types of agreements to have impact on mobility or competition or compensation. The actual analysis to assess their potential impact actually requires a careful understanding of the relevant labor market, the recruiting and the hiring channels, and how compensation is actually determined at these firms.